Hey, everybody, welcome to Startup Basics. I'm your host, Jason Calacanis. You know me, This Week in Startups, the Launch Festival, all that stuff. And I am here with my good friend Todd Carpenter and Rachel Proffitt. They are attorneys at Wilson Sonsini, WSGR. And you guys run the San Francisco, like, hip, cool startup factory, not the, in the Valley office.
Yes, we are the co-heads of the SOMA office.
The SOMA office.
We have a great office in Spear Tower as well, where our M&A and some of our litigators, those guys are situated, who do a fantastic job as well. But yes, we're the
you have the hip office, and then people are like, "What's going on with that hip office down there?"
Startup stuff. Yeah.
Do the other the people who work in the big tower want to go work down there and be in the cool office? Is that like a point of contention?
They like their views, actually.
They like the views.
They'll leave the startups to us. So.
They'll leave the startups to you. All right. Well, listen, we are going through all the important questions that people have to answer as startups. And you have to have a great attorney, obviously. And you have to basically just understand the details of this. And one of the biggest things is how to negotiate a term sheet. And I've been on both sides of this many times. So who should initiate the term sheet, and how should that work? Because that is something that I think, especially just 10 years ago, nobody had ever seen a term sheet. And when one entrepreneur got a term sheet, they wouldn't even show it to another entrepreneur. That was like, could I show it to you? That was kind of like you didn't do that. You wouldn't even show a term sheet to somebody else. Now they're all over the web, and people are explaining them. But who should initiate the term sheet, do you think, today in 2014?
This is probably one of the most exciting parts of our job, because this is sort of when an entrepreneur is most validated in their sort of steps to date, right? All the trials and tribulations that got them there. And usually that overzealous phone call is, someone's really excited, send us a term sheet. We then sort of counsel them that most likely the terms are going to come from the investor who's really excited, and they should wait patiently and maybe talk with the investor about what they're expecting. But it's pretty rare, I think, for the entrepreneur to serve up a term sheet especially if they're first-time entrepreneurs. Okay. And then what should you be looking for in the term sheet? And what is the purpose of the term sheet? Stepping back for a minute.
One thing I think that is changing, and I think that's why you said it's usually the case, is there's the advent of things like Angel List and syndicates of angels, and it is changing the whole ecosystem. You're part of all of that. And oftentimes, because there are a disparate group of angels investing, now it's more common, certainly, than it was 10 years ago, where the entrepreneur would actually be in the right to serve up a term sheet because there's no one else stepping up to take the lead. So I think generally it's still the case that especially if it's a larger institutional VC firm, they will present the term sheet.
Of course,
But if it's if it's a seed round or a large group of
they call it a party round sometimes. When there's 10 investors putting in, on average, $75K each.
Right.
There is nobody doing the term sheet, so then does it fall to the entrepreneur to make one?
It does. It does. And that's an interesting situation that we run into a fair amount because, what do you present to them? You want to be reasonable, but let's protect the company and the entrepreneurs to the extent that we can.
And did people in those situations even read it, or do these angels just all put their $75K up and not even check it?
It depends who the entrepreneur is and what the idea is, right? Because sometimes, like you said, these party rounds, people just want in. So they're kind of like, just tell me where to sign and send the money. But we do try to, counsel folks that there should be some sort of set bit of terms and an opportunity to discuss with their counsel if they need it. And
it's pretty standardized, right? What are the standard 5 items in a term sheet that really matter, do you think?
Well, I think it depends on what security you're selling. Is it a note deal, which there's very few terms there, or is it an equity deal?
Yeah, so let's start with a note. What are the key, sort of concepts of a note?
So I think the key factors in a note term sheet, obviously how much you're going to raise. People will be interested in that. Interest rate, although no one really, it's there, but as long as it's in the range of reasonable, nobody gets too worked up.
And what's reasonable typically?
It's gone down with the Fed rate being lower. So I used to think it would be 6 to 8. Now I think it's more 3 to 6.
So the idea is when I convert this loan into equity, if it took a year and I put $100,000 in and I got 6%, I'm going to get $106,000 worth of the stock.
That's right.
Exactly right.
That's right.
So that's how they should think about it.
Exactly.
So you're getting this tiny small benefit as an angel investor for giving the money as a note.
Yeah, and it's one of the key attributes of a loan.
Right.
And that's kind of what makes a loan, that plus the maturity date. So
if you didn't have it, it couldn't be considered a loan. Is that right? Like technically, if you don't have...
Well, actually, if you don't charge a high enough rate, there are tax implications. There's an imputed rate that the IRS will apply. So, we'll have people say, well, this is friends and family. I want to do zero.
Yeah.
And you really can't if it's characterized as a loan. And that gets into some tricky accounting and tax issues.
So why, like we said in other episodes of Startup Basics, like why even trigger something? Just go with what the standard is. 3, 4, 5%, whatever.
Yep.
Move on. But that's not really that important to angel investors.
No. So you've got that. What's really important to them is probably the conversion discount and the valuation cap, which we see almost uniformly now, don't you?
I agree.
It's,
absolutely. Not 2 years ago, but now it's sort of mainstream to have a valuation cap.
The cap is, this is the highest valuation I will be converted to equity at.
Exactly.
And then the discount is, or at a discount to whatever the round is. But which one actually gets triggered if one is higher than the other? How does that work? Because that's a very confusing part, I think, for a lot of people.
I think this is to help insulate the investors from a major home run on the company side, right? So if you put your valuation cap at $10 million and then the company ends up, again, swinging for the fences and has a Series A at a $25 million pre, you aren't going to be diluted down. Your $75,000, $100,000 is still worth something. And so you're going to get, the $10 million cap in that example. Versus, you end up raising it at $8 million and you're going to probably do the discount instead.
Got it.
But you usually have the protection of it's the lesser of the two.
Exactly.
So it's in favor of the investor who is taking this huge risk by backing the company with a loan. Now, what happens when 2 years go by, because the terms tend to be 2 years, 18 months?
Depends who it's from. I mean, so certain institutions can't have longer than a year, but I think typically it's 1 to 2 years.
1 to 2 years. Because I just had this happen where we were asked to do an extension of a convertible. And I was like, well, why would we do that, right? Like, well, let's convert it. And they were like, well, there's a deal coming or something like that. So explain that. What is the fear that people have with convertibles expiring? Because people have said in the past, like, what happens if all these convertibles happen and the market crashes or tanks? Like, is that a valid concern?
Yeah, I mean, I think it is a valid concern, and I think that's one of the reasons that convertible equity instrument entered the market is because people have referred to colloquially these convertible notes as ticking time bombs because in theory, your investors could call your notes and potentially run the company into bankruptcy. That's worst case scenario, right? And that's why it's good to do business with investors that understand the ecosystem. And when you get a request to extend a note, I bet you usually extend the note. Yeah,
but I was also, let's just talk about this for a second. I kind of pushed the entrepreneur to say, well, why don't we just price the round? So why wouldn't they do that? Because it seems like it's in favor of the company to push it out another year. I mean, we still get interest, but I was just like, let's just convert. Why wouldn't somebody convert? The cost?
The entrepreneur probably doesn't want to because they aren't doing that well right then. In all likelihood, if they've
a fair point,
if they've not raised a qualified financing to cause the trigger to convert, then they're probably not doing well, and they want the extra runway so that they can raise an up round and convert at a higher valuation.
They'd be negotiating against themselves technically if they went to you and said, "What do you think we should convert at?" Right? They might actually want an outside person to come in and put a higher valuation on.
But you will see in some notes people addressing that up front, that if we hit the maturity date and there has not been a qualified financing, then the note will convert at a predetermined rate.
And would that rate be the cap or lower than the cap, I guess?
It depends. I would say most often it's the cap, and it's a fallback to common stock, but it's a voluntary conversion. So the lender can say, fine, let's just get rid of the note. I'll take equity, and you can move on with your company.
And sometimes they even pre-negotiate, a series of preferred stock so that it will convert into like a Series AA. I think Y Combinator occasionally puts that in there.
So that's what this new SAFE document is from YC, Y Combinator, the accelerator, right? They call it SAFE doc? Or?
SAFE is, if you're similar to the capital contribution agreement, you and I have done some deals on that before. It's very similar to that. It's just kind of the next iteration of it. So it's a hybrid debt equity instrument where it doesn't have a maturity date or interest, and it will convert into a future round of preferred stock.
Now, these convertible notes and these debt instruments, why do people do those above pricing around? I mean, that's like a common question. And I literally just was in a meeting this afternoon where the people who were doing the startup said, do you want us to price the round or do you want to do a note? And I said, I leave that up to you. I'm comfortable with either. But I just thought to myself, 5, 6, 7 years ago, people were screaming up and down, don't do convertibles, don't do convertibles. It was like foreboding. And now it's the standard.
I mean, I think there's a variety of reasons. I think it's usually cheaper and quicker to raise convertible notes. There's a lot less terms. We haven't talked about the equity terms yet, but there's far less terms to sort of think about, negotiate, and draft into documents. And also, it does kick the valuation can down the road, right? I mean, yes, there's a cap in there, but that doesn't necessarily mean that that's what your new round is going to be. And to Todd's point from earlier, there is a world in which you just kind of want to put a pin in the valuation discussion and build a product and get it, proved and then go raise money based on that success.
Yeah. And so why were people so against these convertible notes, and why do you think the industry has changed?
I think people have changed their tune and are more accepting of them because they've built in these terms that protect them from the downsides that they were really worried about, like the runaway valuation. You would have these companies that someone would invest $100,000, an angel would invest $100,000, and then the company would get into one of these fantastic accelerator programs, and on demo day they would get a $40 million pre-money valuation before developing a product.
Right.
And suddenly the guy that took the biggest risk at the $100,000 investment, his percentage of the company is so very low.
Right.
And he's not properly compensated for his risk if he just gets a 20% discount.
That's exactly what happened with, I think the first one, if my history serves me correct, was Technorati. I don't want you to speak to it, but there was a whole Technorati brouhaha because all these people, I think Mark Andreessen and a bunch of other people had put money in, and they converted everybody at $30 million, which was spectacular. And people were incensed, and people were pissed in the Valley about this. I don't ever remember that, but it does seem like people have changed and the device has gotten better. Okay, let's talk about what's okay to do with a term sheet and what's not. Because I recently had a situation where somebody got an inside round. The existing investor gave a term sheet to the founder and said, don't shop it. And they didn't shop it. And their competitor, who was had the same performance, got to shop their term sheet and literally got a 4-time valuation, which put me as an angel investor through the roof about this. I went crazy on the VC firm that did this.
Should have put their lawyer at the roof too.
Well, I just told them, I was like, listen, I'm not going to be involved in suing anybody ever, but I will never do business with you again, is what I told this other VC firm. And I'm at war with them right now over this. When should you shop and not shop? And what is the etiquette around this? And how do you communicate that as an entrepreneur? Do you think? I have my own theories, but I want to hear yours.
My theory is any inside-led round should be shopped. Not because because you're conflicted, right? You're already an investor in the company. Theoretically, you're sitting on the board. You don't have as much of an incentive to put a high pre-money valuation in front of the company because that's necessarily going to mean it's going to cost you more to invest more, and it's going to be potentially more dilutive to you in a different way, right? So I think then it's also just good practice, right? Because again, let's be mindful of what we're doing here, which is trying to build an enterprise. It's a growth enterprise that's going to maximize value for stockholders. If you aren't sort of on that right trajectory and you're sort of doing these sort of inside deals, I mean, I know you're not going to be involved in suing people, but there's plenty of other folks that would be incensed. It would
seem, because I had other people tell me, that's probably actionable if they told the founder to not shop it. And then I got on the phone with them, we didn't say that. I was like, well, the founder told me you did.
The founder thinks you said that.
And then it's like, oh. And they're like, are you going to blog it? Are you going to tweet it? I was like, no, I'm just going to talk about it on my show with a bunch of attorneys. No, I just told them, I'm not going to ever say it. I'll never bring it up in terms of the names of people, but I just don't know if I could be in business with you ever, other VC firm.
That's not to say.
I will say, that, I'll come to this theoretical party's somewhat defense and say that it is quite standard in a term sheet to have a no-shop provision.
Absolutely.
But that's once it's signed. So once you've negotiated, and generally what will happen is the entrepreneur will do the, quote, shopping before they sign any term sheet. And so they should go do a market check and make sure that they're getting the right deals. They should be bringing that.
And they shouldn't feel bad about that.
No.
Everybody expects that.
The walk up and down Sand Hill Road, that's de rigueur, that you should be doing that in order to make sure that you're getting the best outcome for everyone involved.
De rigueur, by the way, for people who don't know, is French for don't be stupid. It means standard, right? It's de rigueur. It's like the standard thing to do.
Yes, yeah.
Now, what actually happens when you sign that term sheet? So what are you actually agreeing to?
That's a very good point. And so if you look at any term sheet, a well-written term sheet at least, there should be a provision either at the beginning or it's usually beginning or end, and it will say, this is a non-binding term sheet, except for a couple of provisions, which are usually confidentiality, no shop, and sometimes fees and expenses.
Got it.
And those are binding agreements between the parties, so the company and the investor. And the key from the investor's perspective is like, look, I've committed to this. I've put in a lot of time and effort. I've spent legal dollars to negotiate and sign a term sheet. Let's get this deal done. And frankly, 98% of venture capital deals that get to that stage do get done because people work together collaboratively, and that's kind of the nature.
What's the 2%? When did the 2% not get done?
It's something really unknown comes out.
Like a big diligence issue.
Yeah.
Maybe there's an IP infringement problem or a privacy problem or just something that was just an unknown at the time that they entered into the contract, and they just don't want to invest on those terms.
And so in that case, the VC says to the founder,
it's non-binding, so it's they just usually walk away and say, thanks. If you can address this problem, you can find a workaround. Happy to talk again, but it's not the deal that I thought I was investing in.
Now, what happens when it expires? Because I've been in this situation as well, where I'm trying to close the deal. Now we're at day 31, and I'm getting close to closing, but hey, it's no longer binding. Do people file extensions? And if they don't file extension, would you be out of school to go talk to another person? Have you seen that happen?
Probably less common for that to be a major worry in a financing context versus an M&A deal.
Got it,
but I think the idea once we sign it is we're all going to negotiate in good faith and work to get to the outcome. And to Todd's point, like it's extraordinarily unusual for deals not to close. It would be, not advice we'd give, which is, you have another party that's going to give you a higher valuation. Just slow roll the docs and wait till this to expand, right? You should probably just have the upfront conversation.
That would be really poor taste.
Really poor taste, right?
And you keep bringing up good faith. And so I think this is a really important point to talk about, which is, you have a long career.
Absolutely.
And a lot of times young entrepreneurs maybe lose sight of the fact that hey, you're going to be here for decades probably if you do it right.
In a very small ecosystem.
In a very small ecosystem. And I can tell you there were things I did earlier in my career that were aggressive or I've been known to be a little blunt. And sometimes people are like, hey, you wrote this thing back in 1999 or 2002. They bring it up with me 15 years later. You got to be careful about this, right?
Absolutely.
I think even if it's just one company, you got to think about the path to an exit these days is getting longer and longer. So even if you are relatively on the conservative side and say it's going to be 5 to 7 years, you're going to be partnering with these people that's a long time.
You don't want to leave a bad taste in anybody's mouth when you're doing these negotiations.
Right.
So let's talk about that. Who tells Sequoia or Bill Gurley at Benchmark when they get the term sheet from Ruloff or Bell or some major person, and they say, I would like a couple of million more dollars, or I want, do they have their attorney do that? Or how would you advise, a founder who says, this term sheet's a little too low and I got a higher one, but I want to go with the lower one because I like that firm better. So the dinky, VC firm nobody's heard of is outbidding Sequoia or Benchmark or Excel or, Chamath at Social Capital Partnership. Can you come up to this level? How do you negotiate that? And do you have your attorney do that or do you do that?
It probably depends on the person, right? I think we both have played that role. Sometimes we can counsel them in the background and give them sort of the insight and the data points to go back and talk to them. Because I think sometimes the introduction of lawyers overly complicates things.
Yeah.
But if other times they said, look, I've kind of made it as far as we can make it and I need you to deal with them or deal with their counsel. And I think it's really an entrepreneurial preference.
So if we were on the phone right now and I'm counsel for Chamath or something, you would call counsel for Chamath or you would call Chamath and just say what? Jason would like another $2 million?
I think the reality is, look, it's a deal that's got a lot of interest and you're the preferred partner. You clearly are going to add more value. All the other nice things you want to hear, right? That's got to be accompanied by, but the price to get there is going to cost a little bit. And maybe you don't have to get all the way to the competing bid because again, they want you to be there, but you're going to have to get closer. Otherwise, again, we've got to take theoretically the better deal on the table.
Yeah. So that sounds very nice, actually, the way you said it. How did you say no?
Right. Thank you.
And then what if they say that's our best price? You have to go back to the entrepreneur and say, listen, that's the best price?
Yeah. And there's a point we're going to talk about earlier, which is you don't always have to take the highest valuation. In fact, I've had clients turn down someone who throws in this outrageous bid just to get the deal because you need to pick the best partner.
I had that happen.
To Todd's point, you're going to be effectively married to these people until the end of time for your company. And it's very difficult to get out. So you really want the best partner for the long game.
That's happened to me so many times, both sides. And now, how do I deal with that as an angel? I need some free advice here from you guys because I let's face it, like if people think I'm investing, it kind of validates a little bit. I'm not making a big deal out of myself, but I'm one of the 10 best angel investors out there probably objectively today. So if I say I'm going to invest in something, it kind of pushes the price up and validates it. What should I do? Because I'm not doing term sheets or binding anybody to anything. How do I protect myself, or how do I have that conversation?
Well, you probably should be.
Maybe I should. Like you have to sign a term sheet with me.
Yeah,
but I mean, if you are pricing rounds and setting terms for going back to the party round discussion we had before, I think you would be doing yourself and the entrepreneur a favor having these things be organized, and within those terms, you could very clearly state the things that you want for your protections. I mean, you may want a board seat on some of these companies.
Yeah, I started doing that a little bit,
You know, but I think communicating those expectations up front and making sure that you and the entrepreneur are on the same page, and then that brings everyone else into line around you.
What about exploding? Like, exploding term sheet. Is that still common? Like, you have 48 hours to sign this.
People still serve them up, but I advise clients that, like, if that's really the case, then this is probably not the partner you want to work with. If someone's not going to give you the time that you need in order to understand the terms and be comfortable with them, I really think that the key here is engaging with a partner that's going to be a good long-term business partner.
Right.
And someone that won't allow you to digest things properly and is trying to overly pressure you. Sometimes you're in a situation where that's your only option, and then you can't do much about it. But if you have other options, I think you should explore them and make sure that you're
do the best VCs do that? Do you see the best VCs give these exploding term sheets, or is that something that like the more desperate VCs do?
There's usually an end time period because they don't want this offer out there in perpetuity, right? Because God forbid 3 weeks later they get a sign and they already replaced the deal, right, in their pipeline. But usually, I mean, there's a week to think about it, and that Todd's point is spot on. I mean, they need to talk to their advisors, or I'm sure you advise a lot of startups, and they want your opinion, and is this what you're seeing in the market? And
so there's a reasonable amount of time.
Absolutely.
That's probably a week.
I think,
And most good VCs, if people are still negotiating in good faith, are happy to push that out.
Yes.
It's really, as Rachel said, so that you don't have a document floating out there that's accepted for way further down the line than you anticipated, and then you're somehow bound to do a deal, or you feel obligated.
Really obligated,
So.
Wow. Well, this is I think this is one of those issues, term sheets and negotiating and all these deals that we could talk about for an hour, but we have to stop at a certain point. This is a tremendous amount of information. Thank you, Rachel and Todd. And we'll see you next time on Startup Basics. Thank you.